manager coming in. Nice to see everybody. Hey, Jeff. Nice to see you. Hey, Madeline. Nice to see you. Nice to see everybody. Anita, what's happening? Everyone's looking good. So we're taking there's Lou Mayoko. I haven't seen you in a while, Lou. Thanks for coming. Let's see. All right. We got Michelle Phillips. Thanks. Nice to see you, Michelle. Let's see. Got a few more loading in. Just give me one moment. All right. Well, welcome, everyone. It's Fran McGovern, McGovern Legal Services. Today, I have with me Attorney Mike Palulak and our office manager, Eileen Gambino, and Crystal Ahern is her assistant. And I have to do the administrative thing and read the kind of annoying announcement. These webinars are provided for general informational discussion purposes only. And these webinars do not and cannot form an attorney-client relationship. The information exchange does not constitute legal advice. And to obtain legal advice, you must contact an attorney directly, enter into a written retainer agreement, and present your particular facts. No information discussed during these webinars will be kept confidential. We know that. And now that everyone is out of the COVID zone, there's probably more things going on that probably should be kept confidential. So please don't tell me any confidential information. It was good to see those of you. Some of you I saw last night. Last night was the Community Associations Institute of New Jersey, Community Associations Political Action Committee fundraiser at Topgolf in Edison. It was a nice night. It was nice to see a lot of people out there in person. And I think everyone had a nice time. It was a nice night. The weather was kind of held out. It would look like it was going to be a little sketchy. We got some crazy rain last night in the middle of the night, but it held out for the CPAC event. For those of you who don't know about Community Association Institute, the CPAC raises money for more or less advocacy. Okay, so they use money to support certain initiatives, political initiatives in the legislative arm, basically, that help community associations, condominium associations, et cetera, to either promote new legislation coming on, or more importantly, in my view, to prevent legislation that will harm us, right? Which is, usually that's the thing. Stay aware, prevent things from harming us, and hopefully help us if we can. So let's, Eileen, are you there? We could go to dogs of the day.
Yep.
So we have a couple dogs of the day today. We have three of them. First, we have from EPM, we have Linda. I'm going to mess up your last name. I think it's Busick. Her dogs Captain and Malibu, and April showers bring May flowers. Can we go back to it again? I missed that.
Oh, sorry. Yep. Sorry about that.
That's okay. I didn't get a chance. That's yeah, Captain and Malibu. We got the umbrella. We got we got their raincoats on, which is nice. Very nice raincoats. They're well-dressed dogs. So thank you so much, Linda. And then we also have a special one today. Because we have Bella Mia, who is Danita Susi of Somerset Run. Her dog Bella Mia. We got Bella Mia.
Give me a minute. Yep, having a little trouble. There we go.
There we go. So this is Bella Mia on her 15th birthday, right? Awesome. 15 years old. Nice to see you, Bella Mia. And you have your coat on. You probably get your coat off shortly. It's getting nice and warm out there. So I hope you have a nice spring and summer, and happy birthday, Bella Mia. So thank you very much, Danita. And then we're going to roll right into the new Fannie Mae and Freddie Mac requirements. So really boring, tedious, lawyer, annoying stuff, right? We hate this stuff. But there's a couple things going on, and some people are really concerned about it. Julie McCutcheon, look at you. Haven't seen you in forever. Thanks for coming. So I got my first phone call this morning from a non-client, a unit owner in an association in Central Jersey, saying, "Hey, Fran, I've heard you're known for condo attorney stuff, all this good things, and my association, I was told, does not have Fannie Mae and Freddie Mac approval. I was wondering if I could hire you to kind of go after my association for Fannie Mae and Freddie Mac approval." That's the phone call that you don't want to get. So I said, "Hey, it's so nice. I'm flattered that you call me, but I don't do any of that type of work. I don't think that you have a claim at the moment, but anyway, I'm not your guy." but they're the kind of calls that I think are going to become more common. She's a person who was trying to sell her unit, and her buyer was declined for Fannie Mae and Freddie Mac financing, right? So that's kind of the scary thing we're dealing with. So where are the risks? The risks are, number one, the association has risks, right? Because the association, everyone unfortunately knows and remembers the Champlain Towers disaster, where the building collapsed and lots of people lost their lives, which is horrendous and should never have happened. So much of this is in response to Champlain Towers. Some of it also relates to the mortgage meltdown in 2008, where Fannie Mae and Freddie Mac, for those of you who don't know, are kind of quasi-governmental entities. In fact, I believe at the moment, even though they technically are private entities, I think they are run by a government-appointed proctor, I don't know, a supervisor, moderator, if you will. And what they do is you go get a mortgage from somebody as long as it meets the Fannie Mae and Freddie Mac guidelines, which would make it what they call a conforming loan. A conforming loan, it checks all the boxes. Fannie Mae or Freddie Mac will package that and use it as a basis for securities that are sold in the market, which allows the lenders, your primary lenders that you go to in the market that give mortgages, to have more cash to be able to finance home purchases. The problem is if you don't qualify for Fannie Mae or Freddie Mac, then they cannot be sold, right? They cannot be sold in that market, and they can't be packaged with other loans. So Fannie Mae and Freddie Mac are a way of trying to standardize the products, if you will, and also to standardize the risk profile for the investment interests that they're selling. And really what they're selling is your home mortgages. So in this case, and I know this is really tedious, but I'm going to jump into it anyway. I'm actually going to pull up, for those of you who haven't seen it yet, I'm going to pull up the condominium project questionnaire addendum. Oh my God, how boring is that? So hold on one second. That work? No.
Yep. Yes.
There, okay. So this is the addendum. It's not long, right? Not long. About a page and a third. So I'm going to blast through this pretty quickly, and then we're going to talk about some other stuff. So the first question: when was the last building inspection by a licensed architect or engineer, etc., or building inspector? So that the association can easily answer. Who generally, in my view, their opinions differ on this, is my understanding, my take on this. So long as the association has a manager, which most do, the association's manager will be the one completing this. However, with the help of their professionals, primarily engineers. That's why I said, so I should have been an engineer, because this type of regulation and guideline is really making work for engineers, some work, not crazy work, but some work for engineers, and is going to make work for contractors, right? So it serves two purposes. One, it makes sure that your buildings are in good shape. Two, it makes sure that there's a unified standard of guidelines for the financial instruments that are going into the mortgage market. So they want to know, when was it inspected last? Okay, that's easy. Did the last inspection have any findings related to safety, soundness, structural integrity, etc., habitability? So this is, you're getting into danger, right? So this is where you need engineers, architects, etc., other professionals. This is where, in my opinion, the board and the manager, even though they may be like, hey, that doesn't seem very safe, or maybe that's a risk, I don't think that you're the ones who should be making the call on this. By the way, as a footnote, because I know many of you live in single family 55 and older communities, these guidelines at the moment apply to attached dwellings of 5 or more units attached. So many of you may not be burdened with this right now. That being said, this is how annoying legislation, regulations, etc., can be. If we look at the heading of this condominium project questionnaire, right? They call it condominium project questionnaire. Then you're reading it. This addendum is applicable to both condominium and cooperative products. Okay, that makes some sense. Then it goes on to say, it must be completed by an authorized representative of the homeowners association. What? You just told me this is a condominium or co-op. Why are you referencing homeowners associations, right? It's just so annoying. It's, you're like, the people who live this every day, like you, board members, managers, etc., know the difference between a homeowners association, a condominium association, a co-op, and you would hope that the Freddie Mac, Fannie Mae and Freddie Mac would. In addition, if you look at the heading on their Freddie Mac guideline, what does it say? Single family. When this applies to 5 or more attached, right? So even though I kind of get what they're saying when they say single family, I think what they mean is single dwelling for a single family, but the guidelines apply to 5 or more attached units. It's just so annoying that we're constantly having to parse the wording. And as you can imagine, though, this is what keeps lawyers in business. So going on to section 2, are there recommended repairs, etc.? When will they be done? What are the details on the repairs? Number 3, are you aware of any issues with respect to safety, soundness, structural integrity? Again, this is all engineering and architecture stuff as far as I'm concerned. Number 4, are there any outstanding violations of jurisdictional requirements? Again, this is engineering and architecture as far as I'm concerned. There may be other issues that you may or may not be aware of in existing associations. So what comes to mind, hazards, for example, that you may have to disclose, right? So so we do a fair amount of work on the Gold Coast in New Jersey. So if you know you're a Gold Coast project and you know you're on a capped Superfund site, do you have to disclose that fact on your Fannie Mae, Freddie Mac disclosure? Because even though the hazard is mitigated, we know that under the cap, there is still some environmental issue there. I don't know. You should talk to your engineer professionals about that, because in theory, at least, the project would not have been built or completed if the environmental hazard had not been addressed. Are there any outstanding violations of jurisdictional requirements? Safety, soundness, structure, et cetera. Go ahead and more engineering. If yes, provide the details. Does the project have any funding plan for deferred maintenance? This is a real stumbling block, this question. Number 6, does the project have a funding plan for its deferred maintenance components, items to be repaired or replaced? So most of the associations that I work with would say, yes, we have a funding plan for deferred maintenance, right? You put aside money, deferred maintenance, the accountants can chime in if they'd like. It's usually maintenance that is, say, maybe 2 or 3 years out, right? In a 2 or 3 year window, maybe 1 to 3 year window. It's not reserve funding, which is a longer term capital improvement or capital maintenance repair replacement. It's usually short term, 1 to 3 years. The question there is, some people are not clear whether they're asking you, do you have funds set aside for deferred maintenance, or are you deferring maintenance, right? So the good associations in New Jersey would say, of course, we're putting money aside for deferred maintenance, like power washing of decks and staining of decks, et cetera. That's a deferred maintenance item. But you don't want to say yes to that if what they're really asking is, have you deferred maintenance that should have been maintained already? So it's a weird question to answer, because I would say the project does put aside money and fund for deferred maintenance, but we're not deferring maintenance, right? So if yes, provide a schedule. So that's what you would put, so some associations have schedules for things like power washing and painting of trim, et cetera, power wash and painting of decks. Some associations do regular concrete slabs every year or every 3 years. So do a number of slabs, because nobody that I know of replaces all their sidewalks, for example, in a given year. They'll replace a number of sidewalk slabs per year. So that could be a deferred maintenance item. Some accountants may look at that as a reserve item as well. Has the HOA or cooperative had a reserve study completed? Number 8, right? So again, the associations in New Jersey, we've always talked about, the reserve funding analysis should be done every 3 to 5 years, especially in an inflationary time. We talked about this last week. You should probably get your reserve study updated within 3 years, because the numbers are just wacky off the chart in terms of inflation, especially with respect to petroleum products like roofing shingles and paving asphalt. We also talk about siding, vinyl siding also will go up. It's related to petroleum, et cetera. What is the total of the current reserve account? They give that. Are there any current special assessments unit owners or cooperative shareholders are obligated to pay? So what's happening with this is number 10, they're asking the questions in terms of, is the association funding on a regular basis with its operating account? And is it representing what the load will be for the buyer, right? So the reason for that, I believe, and I don't know this for a fact, is that there are a few, I wouldn't say a lot, of associations that'll say on a disclosure statement prior to these that says, hey, our monthly fee is $250 a month, or that's what our assessment is. However, we have a special assessment on top of that of $150 a month. And you say, well, how long have you had that special assessment? Oh, 5 years, right? That's not a special assessment, really. You're really operating with a, what, $300 or $400 assessment going forward. And you're not fooling anyone by saying that a portion of that really is a special assessment. The reason I believe Fannie Mae and Freddie Mac want to understand what the special assessment situation is in the community is when they're looking at underwriting guidelines for a potential purchaser, they're trying to figure out from a debt to equity ratio and a funding ratio, an ability to pay ratio, can this person pay to live in this house? Can this person afford to live in this unit? Are there any planned special assessments? So as many of you know, especially the high-rise clients out there, if you're doing something like a facade project or a balcony project in a high-rise building, and it is not funded with reserve funds, the special assessment liabilities can be huge, right? To redo balconies or redo building facades. So again, this goes to what is the association's financial profile vis-a-vis someone who wants to buy in there. Has the HOA obtained any loans or finance improvements or deferred maintenance, amount borrowed, et cetera? So they want to know what the load is on the association. So this is very different from co-op to condo. As you know, we represent some co-ops, we represent a number of co-ops out there. In co-op world, it's not unusual at all for the co-op to have an underlying debt load in perpetuity, more or less, that they refinance over time and it grows and shrinks, et cetera. But in condo world, not so much. Historically, it has not been like that, although there are a number of associations now who are taking out fairly sizable loans to do deferred maintenance or maintenance, repair, replacement that would typically be reserve funds, but they have not reserved for the past 30 years. Now they're going to have to pay for it with loans. Many of those loans used to be 10-year loans, but I believe that there are banks out there now offering 20 to 30-year products. So some of that is getting to be more like the co-op world type of things with underlying debt. So that's the example of the form itself, right? So again, in my mind, this should be completed or handled, administered by the property manager with the engineer architect and the board's involvement. So who would sign off on it typically would be I would think the engineer architect and or the manager and or the board president, depending on who's actually answering the questions. But the number one thing is you can't lie. You can't lie. I know that sounds really obvious, but no lying allowed. You're going to get jammed up if you do lie. I'm going to stop the share on that. Okay. Let me see what we have here. Bear with me 1 second. Let's see one other thing. So I'll give you an example. So this, can you see the O&S report up there? Yeah, so this is the O&S report. Bill Payne was kind enough to shoot this over to me. This is an example of what Bill is doing and what his firm is doing at O&S Engineers, and I'm sure the other industry engineers are doing similar, going through this, and this is his opinion on what we just went through on the condominium project questionnaire, right? So this is just his cover letter, no big deal. He's answering the questions, right? So this is Bill, the engineer, answering the questions in the condo questionnaire. When was the last building inspection? Did the last building inspection show significant deferred maintenance, et cetera? Importantly, this is what an engineer has to do or an architect has to do, as opposed to your typical layman on the board or the typical manager who's managing a community. It's defining terms, right? So Fannie Mae defines significant deferred maintenance as blah, 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 blah. And Bill, in this case, goes through from an engineer's perspective, whether or not this association falls into that framework for the Freddie Mac questionnaire, right? So that's why it's important. It's almost like an architect or engineer speaking like a lawyer. Okay, we're going to agree that the defined term shall be this, and now we're going to look at what the building is and whether it falls within that defined category. So this, again, is just a sample of unsafe conditions, again, defined terms. And if where there isn't undefined term, right? So this is unsafe conditions are not explicitly defined by Fannie Mae or Freddie Mac. He as the engineer, the professional, the expert, is going to define what he means when he's giving his opinion. Okay. So this is his report. It's not a crazy report. Let's see, what is it? 5, 6, 7. How many pages do we have here? Not a crazy report. Say figure 10, 15 pages. The $1 million question is, hey, Fran, what does something like this cost? And the real answer is, I don't know. But what I hear in the industry is probably if the engineer has worked with the association in the building in the past and has done things like reserve studies, has done inspections in the past, it might run, say, between $12,000 and $15,000, something like that. But if the association did not work with the engineer and the architect in the past, it may run significantly more because the engineer is going to have to go back and start from scratch. Either hasn't worked with the association in the past or has not worked with the association recently, right? Because an engineer is not going to say, oh, yeah, I was out to your building in 2001, but I'm going to give you an opinion in 2022 based on my report from 2001. Okay, so that's an important thing to look at. It's an important thing to budget for those financial wonks. I know we have some financial wonks that come to these meetings, chairs of the finance committee, et cetera. Think about budgeting for the cost of completion of the Fannie Mae and Freddie Mac process, paying an engineer, paying an architect. Some management companies, it may fall, this process itself may fall outside the scope of the management's agreement. So you may have to pay either an additional flat fee or some a la carte charge for management services. That this is a new thing that has come upon us in the industry. So you have to speak with your management company and speak with your professionals. Many associations are also reaching out to us as well. How will this play out in the long term? I'm not going to try to go on and on and on because I know you want to hear about pools too. How will this play out to us? Well, I think there's significant risk. I think there's significant risk to associations in terms of not doing it properly, not getting the required approvals, and dealing with that going forward. What are some of the risks? Well, your own unit owners may claim that the board is not acting reasonably if they are not doing the things that are specified in the Freddie Mac, Fannie Mae checklist, right? Because what is the touchstone of board member conduct? It's acting reasonably, right? So it's acting reasonably. That's the touchstone. So the woman this morning on the phone said, well, Fran, don't they have a duty? Don't they have a duty to be Fannie Mae and Freddie Mac compliant? And I say, not that I know of. I don't know of anything in the law that compels the association to ensure that you can get you or your buyer can get a conforming mortgage, right? So I don't know anything in the law on that. However, this is the problem. What if someone just makes the claim? This is really not about Freddie Mac or Fannie Mae, Fran. What this is about is it reasonable for, number one, the association not to have had an inspection in forever? Probably not. Is it reasonable for the association to have dangerous conditions and do nothing about it? Probably not. right? Is it reasonable for the association to have outstanding municipal violations with respect to its building structure and major systems? Probably not, right? So a smart lawyer for a seller or a buyer, and this is no secret, so you don't have to keep this confidential, is going to make the argument that, Fran, putting Freddie Mac and Fannie Mae aside, doesn't the board have a duty to maintain these minimum type things, even though it was never spelled out in the law, like things in the Condominium Act or PREDFA, right? So people will say, hey, Fran, this stuff's not required by PREDFA. It's not required by the Condo Act. We're not compelled to do it. The question is, would it be reasonable not to do it? And although it is a lending guideline, right? It's a lending guideline, a lending requirement for marketability of mortgages. What it is backing into is hopefully a prevention of a Champlain Towers going forward, right? So it's not like every state has to go out, and even though many states are putting in guidelines for more regular inspections, more stringent inspections, et cetera. It's not like every state has done that yet. However, what Fannie Mae and Freddie Mac are saying is, hey, here's what we think is the baseline for reasonableness in our lending procedures. And if you don't do it, you're not going to be able to market your mortgages, and people will have to go to non-conforming lenders. So that's that. Who else are the risks? Possible buyers. Buyers may say, listen, I want to live here, and I don't want to go into non-conventional because it's going to cost me more. They're going to require me to put more down. The interest rates may be higher, and I don't want to go that route. So I'm going to bring a claim. So there are issues out there. I think in many respects, I hope, I cross my fingers, the people that attend these seminars, I think are largely doing the right thing, right? Largely doing the right thing. But especially for those of you from the management side of things, we all know we've had clients where we've walked into a new client on the first day and said, oh my God, what has been going on here for the past 20 years, right? I can see some of the managers on screen smiling right now, and we've seen that. And you're like, what the hell? How did this happen? I can't believe it. The stairwells are falling apart, and all the sidewalks are vertically displaced, and personal injury attorneys are throwing their business cards out in the parking lot saying, please give me a call. So there are numerous communities out there that this should push in the right direction. If it does not push them in the right direction, certainly Fannie Mae and Freddie Mac is going to put them on the list and is going to bounce them in terms of lending and underwriting. We are going to have questions on this, but I am going to flip it to Mike to talk about pools a little bit. You good, Mike?
Yeah, I'm good. Thanks. Hello, everybody. Good afternoon. Who else here is sick and tired about talking about pools and COVID restrictions after 2 full years? It has been literally 2 years since we've started talking about this. So if you recall, last month when we had our Friday with Fran, we had all heard that the state of emergency was coming to an end in New Jersey, right, for COVID. That's great. That's not exactly what happened. So the governor was talking about it at the beginning of the month and in February, and then they came out with his executive order, right? So we're kind of ruled by executive order these days. So that was posted on the governor's website the Monday after the last Friday with Fran. So that was March 7th. So in the governor's executive order, he says, okay, the public health emergency in New Jersey has come to an end. It's over. However, the state of emergency still continues. So who knows when that's going to end, if it ever will. So by way of example, the Superstorm Sandy state of emergency still exists today. The reason why they keep that open is it allows the state access to certain federal funding and help from the feds. So maybe it's a good thing for the state to continue with state of emergency sometimes. I don't know. But this one continues. So in his last executive order, continuing the state of emergency, it continues to say that in addition to having a state of emergency, the executive orders and directives from the administrative agencies and the executive branch, for example, the Department of Health, they remain in full effect. So you have to play the executive order game. They then reference another executive order to another one to an addendum, which you go through and you find out that yes, the pool restrictions from last summer, as we sit here today, are still in effect for this coming summer. But let's remember what happened last summer. So we waited around in the spring for the Department of Health to come out with some rules. On May 8th, they came out with their first set of rules, and we were required to have pool ambassadors and social distancing and face masks and everything at the pools. And it seemed a little weird. Later in May, they came out with updated pool restrictions. And then after the 4th of July holiday, when everybody already entered into a contract with their pool companies and had social distancing, or excuse me, the ambassadors for the pools in place, they came out with their final executive order and directives, and that's what we have today. So in there, it states that pool ambassadors are not required, period. They're not required. What is required is really nothing. You are encouraged. So they removed all of the requirements for the pools, and they basically inserted words like strongly encouraged. So for example, it says unvaccinated, this is from the Department of Health guidelines that apply today. Unvaccinated patrons and spectators should be encouraged to wear a mask or face covering while on the pool deck and when social distancing of 6 feet from non-household contacts cannot be maintained. So we're still dealing with phrases like social distancing and 6 feet and face masks and whatnot. But luckily, none of it is an absolute requirement. All of it are encouraged or sometimes strongly encouraged from the Department of Health. All of that being said, it's April, right? It's still a little early. These phrases still now seem kind of antiquated, right? I mean, we're getting into the summer, hopefully soon, and hopefully COVID cases continue to go down. I would suspect the Department of Health is going to come out with updated rules, or at least maybe even remove the restrictions or rules or guidelines that they have in place now at some point in late April, maybe May. We'll have to wait around and see what happens. We'll certainly send something out as soon as they post something. But again, as it stands now, we're stuck with what we had last summer. No ambassadors, strongly encouraged signs basically at the pool for social distancing if you're unvaccinated, face masks if you're unvaccinated, etc. And that's where we stand. Fran, I'll turn it back over to you. You're on mute, Fran.
Yeah, thanks, Mike. So everyone should know this already if you don't. So I've always been a strong champion of Community Associations Institute, both nationally and at the chapter level in New Jersey. Big champion of CAI. And some, I think, people who misunderstand CAI, think it's just this cabal, blah, 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 and they don't like it. I totally and 100% strongly disagree with them. CAI has endless resources educationally, research-wise. There's a research institute at the federal level. There's a research database. There's a lobbying group at the federal level, a lobbying group at the state level to help all of us. But one of the resources I wanted to show you today, just to give you an example, for those of you who don't know, some of you may know her, Dawn Bauman, who is the Senior Vice President for Government and Public Affairs at the national level down in Alexandria, Virginia, and Scott Kennedy, who is the federal, I guess you'd call him a lobbyist, put together a really nice handbook and summary of the Fannie Mae and Freddie Mac new guidelines. So I'll just show you this for a second here, if I can get back to share. That's so determining condo or co-op eligibility for mortgages backed by Fannie Mae and Freddie Mac. So this is a great resource available totally for free on CAI national webpage. Or if you don't want to go on the webpage and look at it, they give you a nice flow chart here of Fannie Mae versus Freddie Mac requirements. Many of them are similar or identical, but some of them are not. You don't want to parse that, but they did a great job of breaking down the requirements for Fannie Mae and Freddie Mac, and the text of the publication is very understandable. It's not legal jargon. It's not engineering jargon. Very nice breakdown, very short, very succinct. Like I said, you could get it on CAI's national webpage, and you could also, I can send it to you if you like. But I do strongly encourage, there's always an advertisement, right? The advertisement is, I really believe that associations should join the Community Associations Institute. You have access, and I'm going to do a show on this probably next month. So by the way, as I said, one second, stop share. So speaking of next month, Mike and I will be away at the Community Associations Institute National Conference on next First Friday with Fran. So on May 6th, we will be away. So we're moving it to May 13th. We will be at the national conference. And we're not going to do one from the national conference because we have to be at classes and sessions, et cetera. But May 13th, we will be doing it at 4 o'clock. But back to my point, I guess, the Community Associations Institute has incredible resources, incredible undiscovered resources that most people have never really even scratched the surface of. And again, I strongly encourage you to do that at the May First Friday with Fran. Hopefully nothing crazier comes up in the meantime. What I would like to do is go through research and resources that are available to managers and board members on the Community Associations Institute national website, so that people can say, hey, you know what? I'd like to call the lawyer, but before I call the lawyer, maybe I'll search the attorney research database on CAI's national website on things like whatever, Fannie Mae compliance. I'm not saying don't call the lawyer. You have to call your lawyer. You can't rely on CAI for legal advice or engineering advice or management advice, but it's a great starting point, right? So before you're speaking with your manager, it always helps to have a little background. Here's another footnote. Some people love it so much that they like to play gotcha on people like me or the manager or the engineer. I'm not encouraging you to play gotcha. We're all on the same team. We're all working together for the same goal. So I'm going to discuss all these resources next month so that we all work together and in a more educated fashion, and that more of you do realize the excellent resources that are available through the Community Associations Institute national webpage. All right, that being said, we're going to jump into some questions. So who is this? Muriel, it seems to me that Fannie Mae and Freddie have chosen the wrong word for deferred to describe what are they talking about. The definition of deferred is put off and act. Yes, I agree with you, Muriel, that they really shouldn't have used the word deferred. They should have used a different word, because when we, at least in New Jersey, talk about deferred maintenance, we're talking about budget line items, that money is being put aside for deferred maintenance. We're not blowing off maintenance that should be done on a regular basis. So I agree with you, Muriel. Malcolm says, on what grounds was the fellow who contacted you going to sue his board related to a failure to have Freddie Mac? So it was actually a woman. She was an investor who had purchased her unit there for cash, and then she was looking to flip it to another buyer. So her argument was, and I don't agree with her argument, but her argument was the association has a duty to bring the association into compliance with Fannie Mae and Freddie Mac. And I said, really, where? Where does it say that in the law? And she couldn't point to anything, which is okay. But what her argument was my buyer may now pay me less because he or she has to go out and pay more in the non-conforming market, right? I know this is all like jargon, non-conforming. So non-conforming is kind of like, has anyone ever seen the movie It's a Wonderful Life? Remember It's a Wonderful Life? That's an awesome movie. It's like the greatest like primer on mortgage banking, right? It's like the old school days where, Tom puts his money in the bank and Joan puts her money in the bank and everyone puts their money in the bank. And then I lend it out to Harry and Harry builds his nice little house and then he pays his mortgage and you lend it out to somebody else. So for those of you who want to get into mortgage law, go out and watch It's a Wonderful Life again. So non-conforming loans would be loans like at the savings and loan in the Wonderful Life movie, right? So what they would do at your typical old school savings and loan would be they would hold their mortgages. So if you got a loan at whatever it was called at the time, I forget the name of the bank in the movie, or the savings and loan in the movie, they would hold the mortgage, and you would make your mortgage payments right to them, right? You would make your mortgage payments right to the local bank or the local savings and loan, and they would take that money in, and then they would loan it out to somebody else. And that's why, in kind of the really awful scene there, when Uncle Harry or whatever, the old he was befuddled, lost all the money. Oh my God, Uncle Harry, where's all the money? Yeah, and although there was a run on the bank, and everyone would say, "I want my money out." And he was saying, "No, we don't have any money. My money, your money is in Jim's house. Your money's in Jeff's house. Your money's in this house, that house," right? So that's how the old school mortgages work. And that's essentially the type of market that people will have to go into in a non-conforming loan scenario, because generally speaking, there's not a market to buy those loans, right? And there are still plenty of financial institutions that will lend on a non-conforming basis. They'll hold the money, or they'll sell it through other channels. They're just not going to sell it through the Fannie Mae, Freddie Mac system. But the argument there was that her buyer either may not be able to buy and she'll lose a buyer over it, or her buyer may not be able to buy for as much money because now she's got to put more money down, or she's going to have to pay additional fees, or she's going to have to pay a higher interest rate. Is there something similar to FHA? Is there reasonable not to be FHA compliant? So FHA compliant is different. It's a different animal than Fannie Mae and Freddie Mac. So thanks for the question, Paul. So FHA, FHA is a little different. So FHA, the big issues with FHA recently have been rental restrictions, and number of rental investor units vis-a-vis the total number. So it used to be very low. It used to be 15% would knock you out of FHA lending. I think that was bumped up after 2008 to 50% that would bump you out of FHA approval.
That's right, Fran. Yeah, it's
Yeah,
50%
okay.
now.
Yep. And then FHA, this has waffled on this a lot over the past 5-6 years. So for a long time, past 5-6 years, in instances, FHA was saying, we will not give you FHA approval if you have a seasoning provision in your rental restriction. A seasoning provision in your rental restriction is if you buy a home within our community, it must be owner occupied for 1 year before you can rent it. It must be owner occupied for 2 years, 3 years, etc. The seasoning provision is the period from purchase to the time it must be owner occupied before it can be rented. So for a long time, and I think FHA is still enforcing this, is besides, I think FHA is doing some spot approvals on this, but in many cases, FHA, I think, is still denying approval for communities if you have a seasoning provision with respect to rentals.
Yeah, that's correct. I'm still not allowing it.
Okay, yep. So the issue there is, Paul, and this is, so as all of you know, one of the big things that we do, not so much now, but when the market is really bad, is we do a lot of collections work on behalf of community associations when people are not paying their assessments, right? So we do a lot of collections work. When I'm talking about FHA approvals, many associations are saying, Fran, we don't want to push to be FHA compliant because generally speaking, and this, whether, you philosophically, you have to decide on your own about this, people without money generally have no money. That makes sense, right? So what the people say is, well, do we want a bunch of people moving in here that can only afford to put 3% down? And then when there's only a little blip in the economy, Fran, I'm giving you collection work because they're not paying their assessments. And they say, Fran, I like you a lot, but I don't want to give you more money to do collection work. Therefore, I'm not working real hard to get FHA approval. There are other associations where they say, Fran, you do whatever is necessary to get FHA approval because we want our units to be liquid, sellable, easily transferred, and we want the best options available for our unit owners who are selling or new unit owners coming in. I have not, however, although I've had a few threats from lawyers, I've never seen a case, I haven't done research on this in a long time, I've never seen a case where an association was compelled to fall within FHA approval. I know that's a long answer to your question there, Paul, but that's my take on it. Mike, you want to take one?
Sure. We were talking about the pools and the COVID restrictions, and Jim Maggot mentioned that Governor Murphy now has COVID, just tested
Really?
positive.
Okay, wow. How about that?
Yeah, it was in the newspaper yesterday. Lisa wrote, do you still recommend having a tracing logbook? So they do state in the current pool COVID requirements that we need to work with the county in the event that they contact us for tracing. So having a tracing logbook is probably a reasonable idea. Not required, but probably a good idea.
Okay.
Fran, the next question I'll read, it says, does the Fannie Mae and Freddie Mac also apply to townhouses of 6 units that are fee simple and are not condos?
You know, I guess I haven't done the research on that. I think I'd have to do the research before giving you an opinion on that. My gut is probably so, but I'd have to do the research on that. There's some hair splitting there, right? Because technically, if you were going to answer yes, you would say, well, you're more than 5 units, they're all attached, you should be bound. But I'd have to look at the definition as to pure fee simple townhouses where there are no common elements. That's what I'm assuming you're saying. Because we even have many townhouses where they are fee simple, but the exterior of the buildings and the roofs are still owned in common, and the association still does them. So that's a really, really good question. I would have to look at the statute the regulation more closely to see if it falls within there, Sue. But thanks for the question. I missed one. Are DC inspection reports, if violations are found, required to be provided when asked about community-wide inspections? I think the answer is yes. I think, who is that? I don't know who sent that question over, but are DCA inspection reports, if violations are found, required to be provided when asked about community-wide inspections? I think the answer would be yes. I don't know if the reports themselves have to be provided, but the information has to be provided. I would, rather than provide it directly, I would provide it through your expert. So if you had a DCA inspection that showed flaws, I would provide all that information to your architect or engineer and have him or her incorporate that into their findings and their opinion. Because unfortunately, a lot of these regulations are overlapping, but even though the DCA may designate things as a violation, they may not, in your architects or engineer opinion, fall within categories that would exclude you from Fannie Mae or Freddie Mac compliance. So for example, many of the managers on the line have probably had 5-year inspections where they're like, there is no like hotel chain thingy, like the hotel chain thingy that locks the door. Sometimes in the DCA inspections, they note things that are just crazy, and your architect or your engineer, whoever's preparing your report to help you with the certification, may say, yeah, that's nice, and we can note it and we'll disclose it to them, but that does not fall within the scope of a serious life, health, safety issue, et cetera, et cetera. It doesn't even fall within the scope of a violation that would impact Fannie Mae and Freddie Mac. But you would need that opinion, not on your own, but from your expert. We have a townhouse owner who has an association tree, one planted by the developer, close to their property. The tree roots are starting to crack his driveway. Historically, the association has cut the roots back, but has not repaired the driveway since it is an owner expense. Now he wants us to repair the driveway too. Are we on safe ground not to repair the driveway? So Jim, that sounds to me like if it's a townhome community, fee simple, you own your lot, you own your house front to back, lot lines, you own your trees, you own your shrubs, etc. Typically in that interpretation, I haven't seen your documents, the tree would be the owner's, the driveway would be the owner's, and it would be the owner's responsibility to deal with it. I don't know why, if it is a fee simple townhouse situation, the association would have historically cut back roots and repaired the driveway or has not repaired the driveway. So you have to look at, number one, what your governing documents say, number two, what the historic practice is. Because one of the problems with being nice and doing things that the association is not obligated to do is oftentimes if you take on a responsibility, it becomes your duty, right? Which is tough, right? You're like, wait a second, I was just trying to help the guy out, until his next door neighbor's like, yeah, I want you to cut my roots too. I know I'm not really answering your question, but I'd have to really look at your governing documents further on that. Michelle Phillips comes up with the Bailey Building and Loan. Yes, that was the good guy. Potter was the bad guy, right? We didn't like that Potter guy. Your complex also has to be FHA approved, which requires quite a lot. Yeah, I don't know of anything that requires FHA approval, but FHA approval has some hassles to it. Mike, do you want to address Danita's question there?
Yes, sure. Danita writes, it sounds like it's best to have signage at the pool that states unvaccinated individuals are strongly recommended to wear masks on the pool deck. And Danita, I wholeheartedly agree. As we sit here today, again, that might change next month, but that's certainly what they are recommending. And Jim writes, better unvaccinated or anyone who does not feel safe should strongly consider not going within the pool area. I'm, again, kind of more in favor of following along the lines of what the Department of Health is saying, which is if you're unvaccinated, you should wear a mask and social distance while on the pool deck. But, you know, again, I have a feeling this is going to be changing in the next month or so.
Right. Okay, so we're creeping up on 5 o'clock now, and we still have a whole bunch on. So I want to thank everybody. And I also want to please ask you a favor. And if you have friends who are interested in this type of stuff, please do not hesitate to send our information to your friends, and we will add them to our mailing list and add them to the First Friday with Fran. Because some people reach out to us and they say, hey, you know, am I allowed to join in? Oh, well, of course, this is an open forum, and we would be happy. The more the merrier, right? So, well, the sun's out, notwithstanding the crazy rain last night. So I hope now that we have daylight savings time, you all go outside and have a really nice afternoon. Good to see everyone. Have a great night. Take care.